Welcome to DME TV. I am Ambrish Saxena and you are watching your program DME Dialogue. This is a program wherein we invite distinguished persons from different fields to talk to us on different issues on the areas where they would have contributed significantly. And today we have with us Mr. MANOJ GOEL, who is an eminent lawyer and who has fought many important cases in the Supreme Court which have made an impact in the legal arena as well as in the political and the social arena of the country. Thank you, Mr. Goel, to spare time to talk to us, and welcome in this program. Mr. Goel, first of all, we would like to know as to how you started your journey in law, what all motivated you to this field, and what has been your journey throughout, in a nutshell, if you can tell us.
See, I was born in a family of lawyers.
Mm-hmm.
4 generations have already practiced before me, and I have seen that environment right from the beginning of my childhood. And perhaps right from those days, it was clear to me that there's nothing else that I can do in life. It's just practice and profession.
Mm-hmm.
Because there's so much that you can do for others here.
Mm-hmm.
You can empower people. You can help them in so many ways, and you can also help in shaping of the law. So you can do all those things in one profession and with dignity and with your own terms. So I was clear that I'm going to do law only. The only difference that my past 4 generations have practiced in district court at a place called Moradabad in Uttar Pradesh. But I moved out from there, and I said that I will be doing practice in Supreme Court. So I started my practice from Supreme Court.
So you did your law from Delhi University, and then you started practicing straight in the Supreme Court. Yeah. So what has been your core areas, as we all know that you have been, focusing more on the constitutional law. What are the other areas you have been working on?
See, criminal law is one area which is a lot in common with constitutional, because everything that is in criminal law touches upon the constitutional rights. Rights.
Mm-hmm.
So that's one common area. But majorly I've been focusing on constitutional law because that's my first love, and that's supposed to be the most complex branch, but at the same time the branch which is directly in sync with the country, society, and whatever is happening, and also immensely shapes the people's life at different points. So therefore, that's one branch which is obviously the most preferred branch. And
there is one case wherein we all know that you made immense contribution as far as the arguments are concerned when this whole Triple Talaq case was there in the Supreme Court. Can you enlighten our viewers your take on this whole issue while the case was in the Supreme Court?
See, the issue in Triple Talaq is not so much about Triple Talaq as I said elsewhere also, that that can be very easily solved. 2 levels it can be solved. Firstly, that in Muslim law it is talaq, or marriage is basically contract, and is a nikahnama which is entered into at the threshold. So if you can just make it term in the nikahnama itself, that Triple Talaq will not apply. So out goes Triple Talaq. It's not there. So the moment the females, Muslim females, they insist that even the Muslim males, they are of the view that Triple Talaq would not be resorted to, they can simply make it a point to incorporate the nikahnama, and that's perfectly valid then.
So it was a very easy suggestion that you put forth. So what was the reason that why such a small thing, such a easy thing was not adopted by the Supreme Court, and the judgment went the other way?
See, the things are that perhaps judges got that without their intervention nothing can happen, and since the matter has come to them, if they don't do that, deal with that, perhaps it will be looking like that they are turning their back towards it. Maybe that was perhaps the reason. But as I said, that the issue was not really about Triple Talaq. There were bigger, larger issues, that how matters which are touching religious aspects of a community, be they Hindu or Muslim or Christian or whatever, who will decide that? and can that be decided on the views of persons who have nothing to do with that religion, or that religion itself will decide what is good or bad or ugly for their religion?
Yeah.
And can you decide the matters of religion, which are essentially matters of beliefs, on the plane of logic? Can you introduce rationality in the beliefs? Because if you do that, then nothing remains in the beliefs.
And the bench itself was divided because two judges
Bench
gave
was
the.
divided on many aspects. In fact, there is no clear majority, if you ask me. In fact, if you ask, majority has in a way approved my view, my argument that I had argued that this is not maintainable.
Yeah.
And 3 judges of the 5 have held that indirectly that there is no state action. Only that 2 judges, Justice Nariman and Justice Lalit,
Yeah.
they have found that Section 2 then amounts to state action.
Yeah.
Whereas other 3 judges found that no, that's not so.
Yeah.
And if that is the correct position, as it is, then the writ petitions are not maintainable in the first place. So the judgment, in fact, is actually all obiter.
Yeah. And once the judgment was made, do you feel it was necessary for the government or the parliament to bring a law? Was not the case that the Supreme Court judgment itself would have been applicable as law? What was the need of bringing a law by the parliament?
So 2 things. One, if the Supreme Court judgment had killed Triple Talaq, then there was no need at all for that.
Yeah.
As it was widely claimed that it is already killed by that, then there was no need at all.
Yeah.
And then you declare it void, something which is already held to be unconstitutional.
Yeah.
What is the need of declaring it to be void? It's absolutely superfluous, redundant, uncalled for.
Yeah.
1. 2, then you criminalize it further. If I pronounce Triple Talaq and that already is declared unconstitutional, therefore it has no consequences attached to it, nothing flows out of it,
Yeah.
then how you criminalize the conduct? You criminalize the conduct if something flows out of it, and that is also something which is precariously dangerous, harmful to somebody.
Yeah, and this is not the case with other religions. I mean, wherever diverse related laws, whether it's Hindus or Christians, no criminality aspect is there.
So you're right. So in a way, when today in Muslim law somebody pronounces Triple Talaq, it is nothing but perhaps his intention that he wants to give talaq, nothing more than that.
Yeah.
If that be so, then in no other religion, mere expression of interest that I'm going to give you talaq attracts anything, much less criminal liability. Then why attach criminal liability here in Muslim religion? It's just beyond thinking.
And what will happen is, suppose tomorrow this common civil code is implemented, then what will be the status of these kind of provisions? Because then the provisions have to be made across for all the religions, whether the same criminal liability will be applicable in that case to Hindus and Christians.
No, since this particular act is especially made applicable to the Muslim community,
Yeah.
Muslim women, therefore, in that event, obviously, this act would not be of any help or applicability.
Yeah.
But in enforcing uniform civil code itself is a very problematic area,
Right.
and perhaps we need to society to mature enough for introduction of such a uniform civil code.
Yeah. Besides, I mean, the other contribution that you have made in the arena of the constitutional law, you have made certain public interest litigations to make the RTI more enforceable. Can you enlighten something on that?
That issues are pending. The issues are basically about whether the president and the governor, they are also within the ambit of the RTI Act, whether the other dignitaries, PM's office, etc., they are within the parameters of the RTI Act or not. And there we believe that since the RTI Act is to promote democracy, is to basically procure information, and in the absence of information, one cannot make democratic choices more effectively.
Right.
Therefore, we have to have a very wide conspectus of the RTI Act, as broad as we can, and therefore the president and governor, why should they be ousted from the jurisdiction of the RTI Act?
Even the political parties are not covered.
All should be. So therefore, the moment you are taking entities out of it by and by, you are making it teethless, and the democracy is that much suffer.
Don't you feel the way the recent changes have been made in the RTI Act that will further weaken the RTI law?
Yes, that's it. That's it. I believe that this need to be challenged. These are liquidating and diluting the effect of the RTI, and that's what I'm saying. That by and by, if you are taking more and more entities out of it, then it's not good for democracy.
Don't you feel that once this Lokpal Act has been made and now the Lokpal has actually been appointed, so whatever, I mean, this coverage of the RTI Act you were talking about, all those dignitaries, all those high-ups can be brought, or they have actually been brought up under the ambit of the Lokpal Act?
No, I don't think that's the correct perspective, because RTI Act is to arm you with information. And that information can be used, in various ways.
Yeah.
But the Lokpal is basically kind of an overseeing institution over the high functionaries, that whether they are involving themselves in corruption or some other dereliction of duties, etc., etc. So you can actually go and make complaints against them to the Lokpal, and Lokpal will get into that. It's kind of like it's an ombudsman, right? But so the domain of the two are entirely different.
Right.
So right to information is a very, very vital thing. It is in keeping with fundamental rights of the citizens, and citizenry is kept informed by that, and that is how one ensures a vibrant democracy, if one is well informed. So therefore RTI is far more important in that sense. Lokpal, yes, is important, but it's in own arena and sphere.
Right. What are the more areas that you are planning to do certain initiatives, certain PILs to make changes in our whole system? Any idea if you can give to our viewers?
No, we don't get into PIL on our own, but if we are approached by some persons, public spirited persons, they have a good cause, we take it up and do it. But so far as the systemic changes are concerned, I think that we don't believe in some major systemic overall, but I think that changes have to be, in bits and pieces, because that's to be effective. Otherwise, if you go for a, very long drawn list of changes, and then it's problematic to actually have it in the first place,
right,
and then to implement them. So I think that we need to have corrections as and when the situation arises. And if you have asked me, then what comes to my mind is that today perhaps I am more keen to see that we readily accept and acknowledge and put it in practice one overarching principle of harmony. Whether it be in our personal life, in social life, whether it be in legal system, because that is something which is very, very vital. And that is perhaps we need to have today in the society also. Too much of brickbatting, too much of conflicts in the society, in political system, in the legal system. We are finding too much of conflicts, which is not good. So I think that we need to have harmony, because it's that harmony which ensures peace, and only a person who is in peace with oneself and is in peace with others that can do something positive to the society. So I think that's the starting point, both for society and for the legal system as well.
Thank you, Mr. Manoj Goel, for talking to us and enlightening us on so many diverse issues. So that was Mr. Manoj Goel with us, who left us with a note of harmony and peace. You are watching this as part of DME Dialogue. Thank you for watching DME TV.